We will now proceed with the comment of Professor Dr. Christian Tietje. He holds the chair on public law, European law, and international public law, and also the current Jean-Monnet Chair on EU value-oriented neighborhood and trade policy. Afterwards, we will have room for discussion and questions, and maybe we can also use the chance to include some questions to Lothar Ehring with regard to his keynote speech, if there is room for that, or if there are open questions. All right.
Thank you very much, and also welcome from my side. Very happy to be here, reading and listening to such fascinating presentations on topics we have a very common interest in. I try to be very quick, which is not due to the presenters, but due to the time restrictions, and hopefully then the possibility really to discuss also with Lothar some of the issues we have raised here. So first on the presentation by Jonas Fechter on geoeconomic analysis of law, an interesting approach coming from this idea of geoeconomics over economic security to economic analysis of law and putting all this together in kind of a methodology. But I have certain doubts, if I may say. That's the idea of making a comment. First of all, please allow me, and don't get me wrong, to just add that it was, of course, not Ludwig who introduced the notion of geoeconomics in 1990. He only put together what has been written for a long time already. Arthur Dix in 1925 is the main work in this regard. And then, of course, we have even more famously today in the literature Albert Hirschman on national power and the structure of foreign trade of 1945 that has laid down this power-oriented approach towards what we, and as Dix already in 1925 said, are calling geoeconomics. So it's not at all a new phenomenon. It came up and went away over the times, of course, after World War I, in the 1920s, after World War II, and then in the Cold War, and now it comes back, all for different geopolitical reasons that then turn into geoeconomic considerations. But the main question in this regard is really first of all, that's the history. Secondly, I think what is necessary to explain is what is exactly the relationship between geoeconomics and economic security, because the explicit underlying rationale of all the instruments we are discussing, maybe not ACI, but many other legal instruments of the European Union, is not geoeconomics, but it's economic security, as it was discussed also by Lothar Ehring this morning. So maybe that should be clarified. What is the relationship between geoeconomics and economic security? Further on, I think it's necessary to go a bit deeper into economic analysis of law, because the basic idea that was presented in the paper, that is homo economicus and taking this over to the state, is not what economic analysis of the law is doing anymore. Richard Posner explicitly left this behind himself and put other considerations in addition to the old hardliner position, so to speak, of homo economicus in his more recent considerations. And then finally, the main question that occurs is, how does that, what has been presented, fit into the methodology of interpreting the law, let's say under Article 31 of the Vienna Convention on the Law of Treaties? What are we doing? You are, if I may address you, you are saying explicitly geoeconomics is a telos of many laws. If it's the telos, then we are in aim and purpose and in a classical means of interpretation. What is new, if I may ask in this regard, if we are just, we are putting some additional value maybe into aim and purpose, as we do it with other issues as well, We do it with any global and public good we have, and so on. But what is new? Is it an additional tool in our toolbox on methodology for interpreting? Is it only something we use under aim and purpose, which then is the applicable methodology? What is it? Is it? I'm skeptical because I think it's just an additional argument under the idea of looking at the telos, of the idea of the legislator on why he did this, and that's what we always do while interpreting the law. And because there's, of course, a certain, let's say, danger in applying geo-economic analysis of law, one could, please allow me if I say it this way, come to the idea that this is a big, beautiful justification for anything while interpreting the law, which of course you're not saying, but at least one should discuss. Secondly, Philippa Ollikainen, very interesting paper on, let's say, interference with versus non-intervention. We are interfering, whereas on the other side we are saying non-intervention. That was basically the idea of your paper. I think it's an interesting idea to put, you were talking about trade-based leverage. I would rather use the more common notion of Brussels effect, which is what you mean, if I understand correctly, which is a famous book on the Brussels effect. So are we essentially doing, we, the European Union, doing by the Brussels effect, the same we are trying to prevent by the ACI? That's an interesting question, intellectually. However, I think it doesn't fit. And the main point for this is that if we look at, for example, CBAM, which you took as an example on the one side, and ACI interests on the other, we have a fundamental difference, and that is under CBAM and other instruments as well, we are trying to protect a global public good, whereas under ACI, and that is the very notion of non-intervention and countermeasure with regard to non-intervention, we are protecting a core sovereignty interest by definition, because non-intervention or intervention only applies if we do have a domaine réservé issue. Yeah? And CBAM and other issues of Brussels effect, let's say, always, I would say, tackle a global public good in this regard. And the question then, of course, is on extraterritoriality, and is that coercion having the Brussels effect with regard to those instruments, yes or no? But again, it's to be discussed under totally different perspectives. And one sees that if we look at Article 20 and the jurisprudence on justification with regard to extraterritorial measures, which is also an issue for CBAM, if it then comes to a final decision sometimes, as we all know, extraterritoriality under Article 20 is, let's say, possible once there is a global common good at stake, but it's certainly not if it's exclusively on a domaine réservé sovereignty issue. And that makes a legal difference if we want or no. But again, I think the idea you had is fascinating. We just need to be cautious, so to speak, not to mix up everything in this regard. There are minor issues. For example, I would be also cautious to use aggressive unilateralism in this regard, because it's a term that has been exclusively been designed in the 1970s with regard to Section 301 by the US. But are we really, for the US, we are back in aggressive unilateralism. But I would be more than hesitant to apply this for EU instruments in this regard. Thank you very much.
All right, thank you very much. Yeah, now we have some time for questions and discussion. So, yeah, are there any questions? Who would like to go first? Yes.
I don't have to go first. I've already spoken far too much today, but I'm happy to break the ice, and I will limit myself to the most important things I have to say. So that's why, with apologies, Jonas, I will not have any comments to you. I find your theory extremely interesting, and bearing in mind the constructive criticism which Christian Tietje gave you, you should and would hopefully continue your endeavor of a new perspective, which I'm sure will be interesting in some way, at least. Now, on the two other presentations, thank you so much. This was fascinating for me to listen. I will not now, go into everything, because we would be here for the rest of the afternoon, and also others should intervene on this. But on your take, Xiaoyu, I think you have identified accurately very core questions and difficulties. I will use a slightly different term, which I think is quite essential in this, unfortunately, indeed too blurry area of international law, namely, as of when does influence, to use a loose term, over other countries in their reserved domain amount to coercion and therefore intervention that is illegal. The Court of Justice in Nicaragua has contributed nothing that is helpful. On the contrary, I mean, there are other parts, even on that, there are other parts of the ruling also, but on this, there are some parts that are useful, but on this, it is, I would say, counterproductive rather than helpful. And unfortunately, much of the very vast literature of many decades is not a lot better, but there are exceptions, and I think they give the most convincing answer, and it is, on the one hand, Marko Milanovic in his AGIL paper, and on the other hand, it is, what's her name again, who wrote that paper from Chatham House on cyber operations and the principle of non-intervention. Name will come back to me immediately, but she's, in my view, the other author who has done even more rigorous work of going through all the material and understanding it for the first time much better and convincingly. I'll use Milanovic's terminology because he is outstandingly pedagogic and persuasive. He delimits the zone between talk, which is never illegal intervention, and force, which is the zone in which there is no debate anymore, where always intervention was unlawful, but where the intervention ban is no longer of interest, because we have a ban on the use of force that does not depend anymore on what you use force for. And it is therefore only below the threshold of the use of force that the ban on intervention still has an independent importance. And he applies, to draw the line, what he calls a severity threshold, or a threshold of sufficient severity. And the ICJ also tried to get there without answering it at all. Milanovic does. We in the anti-coercion instrument tried to answer that. I admit that the bar is a little bit lower in the ACI than in Milanovic's theory, and all that is yet to be determined in quantitative terms. There are these descriptive parameters that some of which you have mentioned, and that is where the answer is to be found to this question you have rightly posed: is any withdrawal of a trade benefit coupled with a demand for policy change, which you're not entitled to demand otherwise, is that immediately coercion? We know that it isn't when it is reciprocal tariff concessions that you demand, right? You give a trade advantage for a trade advantage, and you may also threaten the withdrawal of a trade advantage so far given without being obliged to do so if the other side does not. But there's a logic of even hardball commercial negotiations, and there is a limit beyond, and that is, I think, a limit we still have to identify and also agree on. Internationally, of course, but even internally. And I will not go into more details of policies that exist in the European Union, which are also incentives coupled with policy change in the GSP area and so on. And I don't want to comment on that, but that is where this question must be resolved. Whereas third-party countermeasures, you are in good company. Miles Jackson and Federica Padeu have written repeatedly on this, and so have Reus and Silvestre, understanding the EU's response to coercion against the member states. Think Denmark without the others, or just all the others, but they're all member states. This was member state action only, sending soldiers, no EU policy at stake. And then the EU intervening with a countermeasure. They understand that as collective countermeasure. We don't, for two reasons. One, the breach of non-intervention is not an erga omnes breach. Nobody argues this. It's a bilateral breach only, and therefore one has to, in our view, understand, but this gets very complicated and I won't go into it, understand EU and member states as overlapping territorially for sure, but also in their sovereign rights as overlapping levels of sovereignty. I think Samantha Besson is the most interesting theorist on this question. She goes a lot further though, because for her any regional international organization counts, whereas one can also be more modest, but still include the European Union as not just an international organization, but a state-like actor in limited fields, which should not suddenly no longer be protected by the ban on intervention just because member states have transferred these powers. Pielba, now you also are in excellent company. You have used good language. I will add a bit, although you've used imperialism already. So coercion, EU is coercing other countries through deforestation policies, CBAM, or regulatory imperialism, right? That's a more powerful term. I don't espouse it than Brussels effect. But in my view, what is necessary is a rigorous analysis of where the boundaries exactly are. You have to apply, after understanding it correctly, and that is a challenge in itself, the international customary law, the rules on the limitation of the exercise of sovereignty. And there, I'll give you now my theory, and it's not only mine, but in my view it's the correct one. When the EU prohibits the sale and importation at most, so nothing outside its territory, a customs inspector never takes action outside the territory, and nor is anything prohibited outside. Prescriptive jurisdiction is not being exercised extraterritorially when it is prohibited to bring into the territory and sell their products that have not been manufactured in a way that respects forests, labor, or the climate. And therefore, CBAM, you use the word induce. Christian, you use Brussels effect, but Brussels effect is completely voluntary. This is other countries, without having to do so, copying legislation so that the products produced there by default are more universally sellable. So it is not extraterritorial exercise of territorial sovereignty. And all it does, it conditions the right of selling a product inside your territory on a private actor, namely the producer, not the foreign government. It's not foreign legislation that needs to be adopted. It is a factory abroad that needs to comply with certain standards if it wants to sell something on our territory. That is, in my view, a precise description of what is going on, and then you have to apply this to the prism which you have correctly understood. And lastly, like you, I think that indeed the EU has joined the Global South in the theory, and not just the EU, also the United States. It's a bit weird to say this today, but if we go back one administration and the C2, the G7 declarations in Hiroshima, where also United States and others were on board of denouncing coercion and interference in internal affairs. This is exactly the language of the Global South in the United Nations over decades, with the North disagreeing. But does that mean that we are coming together? No, it doesn't, but for no good reason.
So I think you wanted to add something.
Yeah, just like to clarify that I didn't comment on Xiao's paper because Lothar is in the room and the more specialist on ACI. However, in addition to what Lothar said, I think it's important with regard to your paper to say first, it is very helpful to highlight that it is, of course, substance, but even more the procedure that is so important. Legitimacy by procedure, Niklas Luhmann, I think is an issue here, at least, and therefore it's helpful to have a non-EU person analyzing the ACI from an external perspective. It gives legitimacy in policy sense to the instruments next to all the hardcore legal aspects Lothar also mentioned. And the second aspect I think is very important, which you raised but you're not answering it, is what is geoeconomics, what is economic security, foreign policy or trade? As we all know, it's under the trade competence, the ACI, but you are discussing it in your paper. How far can we go with regard to reference to trade if we go into policy? That's an interesting question, so to speak, in a broader sense on all the issues of geoeconomics, economic security we are currently discussing. And finally, of course, as you put a lot of emphasis on legitimacy, the question, but to be honest, we discussed that before. Can legitimacy outweigh legality? That's, of course, the big question then.
Thank you. So, any other questions? Yes. Okay.
Yeah, thank you. Julian Uhlenbusch from Free University. And I would have two things. First, it's more of a comment, but let's say it like that. And I would also highly support, not highly, but also try to support Pilpa concerning the Brussels effect. As a disclaimer, that's also my research topic in my PhD. And I would not say that the CBAM is part of the Brussels effect. Might be like an add-on, like interrelates with the Brussels effect, but it's a totally different channel. And you can say it's a Brussels effect in a further sense, but then it loses its analytical value. And that's why I found it highly interesting, because it opens another perspective on this, let's say legal, and you should speak of a territorial extension after Joe and Scott, I would say, and how this adds up, and then we get kind of a matrix on how to evaluate this from legal terms with extraterritoriality, territorial extension, and so on. And I really like that. And also maybe on the Global South perspective, I would have a question if you maybe thought about like some procedural solutions, how we could do here. Professor Weiss is also sitting here, and you could maybe say, make at least better consultations, and at least maybe give them some time, like to prepare and add on. The if it's something like the CBAM or even totally, create something new. And I would be highly interested if you have like some ideas how to resolve that. And then to Jonas, it goes also in kind of the same direction. I would, the interpretation part also something that's really interesting, how you can really introduce it into interpretation. That's a really good point of Professor Tietje, I thought, but I was also interested in how you, from the law interpretation, how you can maybe implement it in the lawmaking process. If you thought about that, like, have you thought about like institutional procedural consequences? Those are my two questions then. Thank you.
You had a question.
Hi, Cornelia Furkulice. So since I, together with Professor Weiss, also been researching the anti-coercion instrument, I had actually two questions for you. So first, Pilpa, I was actually wondering whether in your research, maybe you also look at other instruments, not necessarily the CBAM, because as well as Professor Tietje, I think in that case you could argue, for example, there is the public good, while there might be other instances in which maybe the justification for alleged EU coercion is not that strong. For example, might be another case, the GSP Plus scheme, which could be potentially also be perceived as another instance, yeah? With respect to the threshold, because everyone is agreeing here that there is no currently established standard, I was actually thinking while also doing research whether the EU, by tabling these instruments, setting a precedent, and also now we see other countries that look into adopting similar instruments, aren't in fact establishing right now, or that we have an incipient custom. So could it be that the instrument itself will help with establishing the custom and influence actually public international law in the future? Yeah, thank you.
Well, thank you very much for your question on legal interpretation, and I think this was also the point you made. So I think it's very important to differentiate between the different sort of methodological dimensions of, economic theory of law, but also a potentially future geoeconomic analysis of law. And I think this was also your criticism and your worry that, you said at some point that maybe at the end of the day you can do anything with it. And I think in order not to do anything with it, we really have to, if we use it or if you use geoeconomics as an interpretive tool, we really first of all have to analyze whether the law is actually about geoeconomics. And I would argue, for instance, with investment screening, that wasn't so clear at the beginning, because for a very long time the legal text still doesn't say much about geoeconomics, but also the legal documents didn't say anything about it, right? The legislative documents, etc., didn't say much. There are a few comments now, but not very, I would say, very sort of holistic, but it's definitely moving into that direction. So that is, in a sense, very classical legal interpretation. It's just what we always do, yes, what we always do in a sense. But if we say, therefore, we don't need it, then we could also say, why do we need economic analysis of law? And in fact, I believe some of those criticisms are exactly what economic analysis of law also faced in the beginning of just, why do we need it? We can just look at an individual act and then say, well, if this act is about making market processes more efficient, then, well, we can just use normal legal interpretation for it. And in a sense, that's correct, but in a sense, it's not correct if we have a phenomenon that is kind of overarching, which kind of comprises, in my opinion, a lot of legal acts, not just investment screening, but also potentially the anti-coercion instrument, foreign subsidies regulation, etc., export controls, now sanctions. And if you want to kind of have an overarching telos, as it were, then I think it's very helpful to have a unifying theory, which of course doesn't prevent us from still looking at the individual act and making sure we are not just taking a broad brush. And I would actually agree on that criticism, because that is what happens very often with economic analysis of law, that you don't really look at the text so much. You just say, well, it's about efficiency, so we make it all about efficiency, and we don't care about the actual statute anymore. That being said, that's just one dimension, right? I mean, in Germany, we are very much focused on legal interpretation of a specific legal text. But you can do other things with the law, right? You can look at it more from a sociological perspective. That's what the Americans tend to do. That's what the British tend to do, and others, I'm sure, as well. And you can ask yourself, well, is this really a meaningful law? Does it really do what we want it to do? Or in fact, well, maybe it does what it wants to do, but it's it's very much countering other interests we have, such as geoeconomic interests. And I would say that's still a valid dimension of law, but it's not something that the courts can do, right? A court, for example, analyzing the AI Act, a court cannot say, well, it's all about geoeconomics, because it's not, right? But we can still, from a legally scholarly point of view, still say, well, this act, for instance, is countering our attempts to become more economically secure. So I think it's really about making sure that you're in the right category and in the right dimension.
Okay, well, thank you for the very interesting comments and questions. As the first one, I'll take what should be done about the position of the Global South within the remit of these EU environmental leverage instruments. Well, there I think slowly but surely, or not even that slowly, the consensus, at least in scholarship, is that if the EU does indeed want to influence, particularly in the remit of climate obligations, then it has to pay full heed to the Global South's understanding of common but differentiated responsibilities and respective capacities, particularly when it comes to least developed countries and small island developing states. Now, that is at least a sort of bottom line, lowest threshold level of consensus that has been reached, is that perhaps you should provide an exemption for those countries from these instruments. Because the EU, for them, is a huge, export market. A large percentage of their GDP is simply for the EU market, and they suffer a huge brunt from these instruments as well as climate change. So you could argue that there is a sort of cumulative injustice now being met by these countries. And I think that's something that the EU should take seriously if it really wants to use trade leverage in order to respond to common concerns. Now, actually, I'd like to take that opportunity in terms of responding to common concerns to address the issue of, okay, there is a stark difference between responding to common concerns and then other kinds of influence. I agree. Yet, that does not get us to the question of how to respond to these common concerns. And I think that's the more important and interesting question. The question is not whether to respond to common concerns, but how to respond to them. And in that sense, the key, to me at least, is the question of what are the consequences of the approach that we adopt? I've been interested, and I have actually looked at other environmental leverage instruments in that regard, and I think there's an interesting question there in terms of how much of the kinds of concerns about a level playing field and competitiveness and so on are actually perpetuated and engendered by the choice of the instruments that we are using to respond to these concerns, right? Would it, in some sense, not be more simple, at least hedging aside the question of political feasibility, to simply agree that we should phase out fossil fuels? Does that not get us potentially to a different path? So I would like to sort of see more options in terms of how we respond to this in that sense. And then if I may still hold on to the microphone for a bit and address the question about whether there is an incipient custom. I think that is an interesting question, and in some sense, yes, there probably is. But I think forming that custom is something, of course, that the EU cannot do alone. As you know, customary international law is formed by us looking at state practice and opinio juris. Now, it seems to me that that is largely a task for us lawyers to do and to articulate, right? But the heteronomous system that is international law also, of course, means that the EU cannot do it by itself, and it can't guard, or at least it can't control what other states make of its assertions. And that's kind of what I was interested in exploring in the paper that I presented. Okay.
Okay, I think today I'm the most like benefited from this seminar because I heard so many feedbacks, not only from Professor Tietje and also from Dr. Yering. I think it's so important for me because when I'm writing this ACI like anti-corruption instrument, the main concern is that the world right now, because international relations are so connected, more and more countries that are imposing or adopting this kind of instrument. So I want to discuss more, but at the same time, I totally agree with both of their comments that I missed some hardcore questions. I think I need to really dive deeper into how to define the legitimacy and how to say under geo-economic and what is intertwined. But for my paper, I think I need to revise a lot according to their advices, especially for when you point out to the different papers, and for me, I have been reading this, not only Angelina's and the Milan Noik, and so the Paduan's writings, they are very beneficial. I think that's really shed light to me for to have a future revision. And due to the time limitation, I'll just give this microphone to Anna.
So I think, was there another question before? Somewhere? Yes? Of course.
Hi, I'm Caroline from Göttingen University here in Germany. I have a question to Jonas. So when I was listening to your presentation, I was wondering if we look at law from a solely geo-economic perspective, where does the human come into play? So how can we tackle human rights obligations, for example, if we look at the law from a geo-economic perspective? Because I think you mentioned something about that the incentive to states to look at law from a geo-economic perspective are things like power and economic security and whatever. But I think that there is sort of a gap with the actual humans and the human rights obligations that might come into play with law as well. So I was just wondering how,
A very good question. I think I begin to realize that some of the things that seem to be clear in my mind may not have been clear while I presented it. So I think the important thing is realist and geoeconomic theory is just one slice of reality, right? There are many more realities, and an important one, and maybe an even more important one, certainly in my opinion, is human rights, right? The EU should care about human rights. Germany should care about human rights. In fact, I think it's more important to act in a way that protects human rights than just think about security. I absolutely agree with you. But there's also one other side to reality. It's not only about human rights, it's not only about environmental rights, even though those are extremely important, but it's also about security. And I think for a very long time in Europe and in Germany, we were very complacent because we simply assumed that the international system is secure, and we didn't really reflect too much on the fact that, there was a big brother in Washington protecting us for a long time. So what I do with this theory, or what I want to propose with this method, is we also have to look at the slice of reality that is about security, right? And only in that regard, states act in that way. So the reality is cumulative, right? States do this, states do that, states do other things. But one thing they also do is care about security, and they do more and more do so, right? We have witnessed that over the past 10 years. And only when we look at that piece of the cake, I think geoeconomic analysis of law can be helpful, keeping in mind that we also have other pieces of reality that we need to care about. If we take, again, economic analysis of law, and that is why I believe it's so important or so helpful to take that example, we all know that individuals do not always act rationally and out of self-interest, right? And I think that also goes back to Professor Tietje's criticism. Of course, Homo economicus is not a reality. It's never been there. There's not a single human being that is a Homo economicus. And we have a vast amount of literature on that. It's behavioral economics. You all do not act rationally. Kahneman and Tversky wrote a lot about that. But as a model, it is helpful because we also act economically rational. We do not act all the time irrationally. Sometimes we do act rationally, and it's a helpful model, a model being a simplification of reality, not the fullness of reality. All right? So human rights are important, that's what I want to say. Is there some other question, or?
Quickly throw in the name, which I couldn't find quickly enough when I wanted to express it, Harriet Moynihan. And I want to give credit to her because I think that is done too seldom for her really masterful work, also in other areas of international law, like aid and assistance to wrongful acts. So who wants to say something next? But otherwise, just a comment on custom. Very fair points. Obviously, custom can be created only jointly. And you all know, I fear, this unresolved conundrum of what exactly is state practice, opinio juris, is the practice also opinio juris, and vice versa, that we will not resolve now if it hasn't been resolved by the scholars over so many decades. But you know, I do take the point, at least that's how I would put it also, that the EU going out there, the G7 going out there, that is either opinio juris or practice. It would be practice if there is action under the ACI one day, that should count. And now comes a word of warning. I am worried because how many cases have we seen recently where economic coercion happened and it was called out as such and rejected as being unlawful under international law for that reason. If that is not happening and no action is taken on that basis, what does that do to customary international law?
All right, I think we have time for like one more quick question, if there is any. Well, if not, then we can obviously continue the discussion during our coffee break. Yeah, I would say we continue at 4:30, right? All right.